our guest speaker for this afternoon. He's the director of the Center for First Amendment Studies and a professor of rhetoric in our Department of Communication Studies. Let's have a hand for Dr. Kevin Johnson.
So yes, I'm Dr. Kevin Johnson. I'm the director of the Center for First Amendment Studies and also a professor in our Communication Studies department. I'd like to thank President Connolly, Provost Jersky, Dean Wallace, the Department of Communication Studies, the faculty for supporting the event, Professor Fox for allowing me to speak to all of you today, and for all of you for being here today. If you're not aware, today is Constitution Day. Woo-woo! Right? All right. Constitution Day, a little bit of background. For all universities, all educational institutions receiving federal funds, it's a federal mandate that there be a Constitution Day event held on September 17th of every year. And when September 17th falls on a Saturday or Sunday, the event can happen anywhere the week before or anywhere the week after. And so today is our university's observance of Constitution Day. And in accordance with that, I would like to talk a little bit about the Constitution and the First Amendment and the Senate confirmation hearings of the Supreme Court Justice, and just to provide a little bit of a background for being an informed citizen in the United States. The first question that I have to you is, how many justices are currently serving on the Supreme Court? Anybody know the answer to that?
9.
Well, yeah, kinda. How many?
8.
8, right? Yeah. Yeah, there's 8 current ones. That's a trick question, granted. Usually there's 9, but Justice Kennedy submitted his letter of resignation or retirement as of July 31st. So the court currently has 8 members while we're awaiting the confirmation of a 9th justice to serve for the court. How many of you in this room who have not had my class before, because most of my students by the end of my semester know the answer to this question, how many of you can name all 8 of the current Supreme Court justices? All right, so we have one that can name all 8 of the Supreme Court justices. That's not surprising. Roughly 2/3 of the American public cannot name a single Supreme Court justice. Only 1% of the American public, roughly the demographic that translates into this classroom, 1% can name all of the current active Supreme Court justices. And so, while most people, if not everyone in the United States, knows who the President of the United States is, most people do not know the collective number and or the number of people and or the actual people that have the ability to overrule laws that are signed into effect if they violate the constitutional guarantees. So one of the tasks in our educated citizenry is to probably understand how this Supreme Court works, how this Supreme Court confirmation hearing works, how the task of constitutional interpretation works, so that we can be better informed about how this operates in our democratic life. So today, I want to give a little preview of our talk. And the talk is only going to be for a total of 55 minutes. We're not going to take a whole lot of time today, but the way that we're going to structure the talk today is I'll begin by talking a little bit about my training in rhetoric and what is rhetoric. Rhetoric is something that you'll learn a little bit more in this class later on in the semester as a gateway to communication. I'll then, after talking a little bit about rhetoric, I'll talk about the way and modes that we go about interpreting the Constitution. How is it that we set up and understand the different contests over meaning in the constitutional text? And then I'll finally turn to the confirmation hearings with a brief history of confirmation hearings, the increased politicization of the process of the confirmation hearings, and maybe even a little bit about the current confirmation hearings that are happening with Judge Kavanaugh. So I'd like to begin with a discussion about my training and my background and my orientation that I have toward the study of the Constitution. And that comes from a rich tradition of rhetorical training. Rhetoric dates them back to the ancient Greeks and the polis and democratic life and the active participation of citizens in the ancient Greek democratic forum, right? And for people that were participating in that forum, rhetoric was vital. It was necessary to be able to persuade people, to be able to talk to people, to relate to other people, to live together and work together in a society structured by people that had a shared sense of power, right? Democracy is about shared sense of powers, for example. Aristotle defined rhetoric as the faculty of discerning in any given situation the available means of persuasion. He believed that the way that we make the best decisions collectively is to be able to advance arguments, to be able to discuss the controversies of the day, and so that we can reach what could be the most imperfect, but also the best guess that we might be able to make in a given society. So that's where it's initially rooted. However, rhetoric's undergone a bunch of different changes over the years, and we've come to think about the way that persuasion works and the way that language works in a variety of contexts. For example, the scholar Krista Ratcliffe defined rhetoric, and this is really seductive, the way that we use language and the way that language uses us. Right? It's that latter part that's fairly interesting, right? That language would operate on us in some way. For example, many of you do not remember the first words that you uttered. You existed prior to the language that you were born into. Most of us cannot remember the very moment that you screamed in the Seuss language, "I'm an I," right? "Happy birthday to me, I am an I." We don't remember that initial time per se when you remembered and knew that you were you. That's because we didn't necessarily make our choice, but to be born into language in particular ways. And with our being born into language, language has come to program our minds in particular ways. Things that are formulated as thoughts, beliefs, attitudes, behaviors, etc., may all be bound up into the way that language enters our mind. Theorist Kenneth Bork said that the limits of our vocabulary is the limits of our world. The way that we literally have the vocabulary for different ways of thinking are based in the very way that we have words to be able to describe that reality. Richard Sherwitz and Jim Hykins, they defined rhetoric as the description of reality through language. How we describe reality, which words we choose to describe, which words are chosen for us in particular ways that make up our thought, even if we're not aware of that. When you see something happen in person and you choose to describe that reality of what's going down in one way versus describing what's going down in a different way, right? We call these really fancy things hermeneutic grids. It's the art of interpretation. It's the art of ascribing particular languages to acts that occur in the world. Rhetoricians are concerned, therefore, with the myriad of human things in the way that we think about human affairs. We're caught up in a lot of study about beliefs, of pleasures, of desires, of risks, of urgencies, of possibilities, of potentialities, of contingencies, of excesses of logic, of changes, of becomings, and of timings. All of these are things that rhetorical scholars think about. And at the heart of many of the things that we talk about with the Constitution is the way that we interpret the words from the constitutional text to the current events that occur today, that take the form of legal cases that enter their way through the courtroom that have to be measured against the guarantees that occur in the Constitution. Okay? So this leads me to the second area of the talk. When we have this idea of rhetoric involved in the way that we interpret our reality through language and the meaning that we think about in the world, that leads to different ways that we have to then measure the words in the Constitution to the current events and things that occur in our world, okay? And what that means is that people might disagree, right? And they do disagree because there's many different ways that we can define words in the Constitution. How so? Let's take the First Amendment. Anybody want to give a stab at what the 5 freedoms are in the First Amendment? You can count them on one hand. That's how I always remember them. What freedoms are involved in the First Amendment? Speech and assembly, yeah. Okay, that's okay. We'll collectively do it. We have the freedom of speech, the freedom of assembly, the freedom of religion, the free exercise of religion, yes. Protest, speech, and assembly are related to that, of course, but we have speech, assembly, and we have religion. Freedom of press, right? And? Nope, that's Second Amendment. Yeah? Petition the government for redress of grievances, okay? So these are the 5 freedoms that are built into the First Amendment. The words of the First Amendment says, Congress shall make no law abridging the freedom of speech. No law. They shall make no law. It's pretty clear. Congress shall make no law. But can you say anything in American society? Can you say everything that you want? Why not? The words of the First Amendment appear pretty well set in stone. It's pretty clear, right? Congress shall make no law. If they make a law, then why wouldn't they be able to do that?
You can't say something that might hurt other individuals, like yell fire in the theater.
Well, okay, so risks to public safety, right? Hurt is a very difficult thing because you can say things that do hurt other people, but things like fighting words, things like shouting fire in a crowded theater, you can't do because there are safety issues, right? So public safety issues. So we also have a right to be secure in our possessions and in our personal properties and things like of that nature. So what happens if I want to practice my freedom of assembly in front of a fire hydrant? The courts may find that these freedoms conflict, right? These freedoms conflict. So we need to negotiate a meaning out of this. So it's a dynamic document that requires interpretation. And what I want to do today is to introduce you to 6 modalities of constitutional interpretation. These modalities are originally advanced by the work of Philip Bobbitt on the art of constitutional interpretation. And all the justices of the Supreme Court will employ one or more of the following modalities of constitutional interpretation when they're trying to figure out the meaning of the words in the constitutional text. The first of those is the historical modality. The historical modality says, in order to understand what the Constitution means, we have to go back to when that part of the Constitution was passed and figure out what it meant to the people who passed it. That's where the democratic negotiation occurred. That's when the meaning was passed. And so what it meant then is what it means today, right? That's what a historical interpretation would say. So Justice Scalia, the late Justice Scalia, for example, was a very large advocate of historical interpretations of the text. And he says that matters are pretty clear on certain issues. Issues like cruel and unusual punishment. Is the death penalty cruel and unusual punishment? Justice Scalia would say, well, of course it's not cruel and unusual punishment. When they were adopting the Constitution and they put the Bill of Rights into place and they said that cruel and unusual punishment should be the right against being punished cruelly and unusually should be enshrined in the Bill of Rights, they were still practicing the death penalty. They were hanging people outside of courtrooms. So of course they didn't mean cruel and unusual punishment to be inclusive of the death penalty, right? Others that are arguing from the historical interpretation might counter that kind of argument from a historical rationale. They might say, of course, that that in history, cruel and unusual punishment didn't include things like hangings or firing lines and things like that. However, the founders did not practice the death penalty by gas chamber or by lethal injection. So they might make an argument that says that any laws that are in favor of the gas chamber or that are in favor of lethal injection are cruel and unusual punishment as defined by the framers. Only hangings and mass shootings and firing squads can be considered to not be cruel and unusual punishment. Now that's a pretty wild argument we don't hear very often, right? But it's within that historical text, that historical basis, that they're rooting their rationales, even if they disagree with one another in terms of the conclusion. It's about how do we define what it means. Does that make sense? So the second modality of constitutional interpretation is the textual modality. The textual modality takes a look and says, what do the words on the page mean? What is the actual definition of the words on the page? So when we say that Congress shall make no law abridging the freedom of speech, and a case comes in front of a judge that uses solely a textual type of reasoning, and that case involves, say, online speech, things that you've said online by way of print, right? The justice might say, I don't know, if you look up speech in the dictionary, it means the act of oral communication. It doesn't include words in an internet forum. So when it says that Congress shall make no law abridging the freedom of speech, you don't have the right to write whatever you want, maybe in the freedom of press. Let's take a look at what press means, right? When we're talking about the press, it means the printing press, right? When we take a look at what a press means, it means mass distribution of pamphlets and flyers. Your online communication is not pamphlets and flyers. There's no press involved. It's all digital. Therefore, it can't be the definition of speech or press. It's not pressing anything. It's just electronically transferring, which isn't in the Constitution. And the textualists would say that maybe, just maybe, the reason why we need to have a textual interpretation of it here is because America has to have that conversation. They need to decide it for themselves through the legal process. If they want rights to extend to online communication, amend the Constitution. It's built within the document. In a democracy, those are the things that we talk about. Those are the bills that we pass. It's not the court's job to create a new meaning for a thing that didn't exist at that time, right? So a textualist might interpret it from that perspective. You can see now maybe how the historical and the textual might go together a little bit, right? They might be related to each other, finding the definition that it meant at the time in history and so forth and so on. So some justices employ both particular types of interpretation. The third type is a prudential interpretation. And the prudential interpretation basically posits the idea that the words should mean the most pragmatic meaning, the thing that's going to work the best for everybody. It may not be rooted in a strict text. It may not be rooted in history. But in order for the thing to work for us, for it to work administratively and so forth, that we need to interpret it in XYZ way, right? So for example, if I know in my judicial opinion that there's going to be 5,000 cases that are filed tomorrow in the federal courts, and I know that no courts can really handle that backlog of cases, I might prudentially interpret it to say, yes, that's what it means today. The court is clarifying it today, but for all future cases. It's not going to be retroactive. It's not going to be relevant to the previous instances that happened only at this point moving forward, because that's a pragmatic definition of the term that you establish in precedent. Does that make sense? Another way that they might interpret it is to privilege a broad interpretation of a statute at certain times, because sometimes broad interpretations of statutes might be necessary to carry out the objectives of administrators, right? This is what was at issue in Morse versus Frederick, for example, when Joseph Frederick unfurled a banner that said "Bong hits for Jesus," right? Deborah Morse, the principal at Juneau High School at the time, had to make a split-second decision. Is this promoting illegal drug use that's not protected speech, or is it freedom of speech for the student to be able to express themselves in a marginally non-academic context, right? And what the court ultimately concluded was that the principal had to make this split-second decision. And administrators can't fear for losing their houses based on split-second decisions. It's not pragmatic for any administrator to be able to do that, let alone it's not pragmatic because who would want to have that job? Nobody would sign up to have that job if they can instantly lose their house for this split-second decision that may be a gray area that they didn't necessarily know was set in stone at the time, right? So the court ruled 5-4 in favor of Deborah Morse in that case and said that her interpretation was reasonable given the way that people think about drug use. Bong hits for Jesus reasonably promoted illegal drug use, is what the court said. Now, what is reasonable? What is not? In this case, reasonability was defined in pragmatic terms, right? So the modality of constitutional interpretation that has to do with this pragmatic question is the prudential modality. The fourth way is through a doctrinal modality. Doctrinal modality looks to the doctrines of the court. It's rooted in stare decisis, let the decision stand. It's meant to give stability to the court, to be able to know within a reasonable kind of way what the law kind of is on this subject, right? If the Supreme Court goes back and forth, reverses and doesn't reverse, and reverses and doesn't reverse, then lawyers won't know what the heck is the law when they're advising their clients, for example, right? So the justices using the doctrinal modality, and all of them do this, they all use prior cases to reason and provide a rationale for the consistency of their position in the particular case. Now, they might choose different cases, right? Because now we're going to go back to the historical interpretation. If you define it historically, you might find that this particular precedent was a bad precedent because it's not rooted in the actual definition, so they overrule that precedent in favor of the other ones to make all of the other precedents consistent, right? But from their reasoning process, they're trying to use past precedents to be able to give some consistency to the standards under which they interpret. The fifth type of constitutional modality is the structural modality. This is the modality that requires justices to maybe privilege one amendment over another or one clause over another when they conflict. The right to assembly in front of a fire hydrant is one example, right? But a more straightforward example is you have the right to assembly in a way that blocks people from entering the voting booth. No, because that violates the right to vote, right? So yes, you have the right of assembly, but structurally, you can't have the right to assemble in front of a polling place blocking people's right to vote and have a right to vote, right? So you have to have an exception built in, right? You have this thing that's built within the structure of the constitutional text where certain modalities become privileged over other modalities, right? And then the last modality is the ethical modality. And the ethical modality says that the Constitution has certain principles that are built into it. It's not textual in its orientation. It's not going to look at what does each word mean. It's going to say that there are certain values that were promised and found in that originary document, right? And that originary document was meant to evolve over time to the adapting principles so that it works for a given moment and that it would reflect a commitment to that larger overarching ethical commitment as we mature. So just as an infant is born and an infant evolves in their own beliefs as they progress to adulthood, so does America. We have these initial values, initial things that are there, but they build over time, and they need to maybe be adapted to reflect the given moments in our history, right? For example, Brown versus Board of Education. For example, the right to vote, right? The idea that we the people has changed now. We the people now doesn't mean the same thing as we the people then. There's a value that's inherent in we the people that is attempting to be perpetually realized. And so maybe that means that to be ethically committed to that idea that is not yet realized, we have to interpret the Constitution in a particular way, in this case today, right? The ethical interpretation says that we are the ones that have to live with this document. We didn't create this document. So the ethical commitment says, what are the values in that document that continue to resonate today, and how might that influence the interpretations that we might have in this particular case, right? So taken together, what adds to the complexity of this is that different judges have different hybrids, different interpretive hybrids. Some are historical, textual, prudential, doctrinal. Some are ethical, doctrinal. Some are prudential, textual, doctrinal, right? They view the constitutional text in different ways, different meanings, rooted in the historical tradition of rhetoric, different hermeneutic or interpretive grids, different ways that they put an interpretive grid onto particular cases that come before them that allow them to see the particular act in a particular way when it comes to the interpretation and the reasoning that would occur within the Constitution. Okay? So those are the basics of rhetoric. Those are the basics of the way that the Constitution is interpreted and the complexity. Let me talk just briefly a little bit about the confirmation hearings. Does anybody know what is required to be a Supreme Court justice? What are the requirements to be a Supreme Court justice? Yeah, so the president has to nominate you and the Senate has to consent, advise and consent to you if you want to be a Supreme Court justice. Those are the only two requirements. You don't have to have a law degree. You don't have to be arguably even a citizen of the United States. You don't have to be of a certain age. You could be 10 years old. The likelihood of those things happening are not very high, right? But all that's required to be a Supreme Court justice is a nomination from the president and the advice and consent of the Senate, right? So the confirmation hearing is one of those times where the Senate is involved in a questioning process to try to do some vetting in advance. This is also a public testimony. It's one that many members of the public have paid attention to. Has anybody watched the entire proceedings of Judge Kavanaugh? Not the entire. How many of you have seen at least parts of it? So not very many, surprisingly, right? It's not entirely surprising to me as a constitutional scholar that that would be the case, because C-SPAN is not necessarily on your regular Facebook feed, although sometimes it might be, right? Maybe we've unfriended or defriended all the people that would circulate that kind of thing. and we've gotten to that place. But the public testimony of a Senate confirmation hearing is just that. It's very public. It's the opportunity for people and the constituents to let their senators know what they think about the justice based on the things that may be included in the public testimony, right? And so it's the opportunity for this particular process to happen. I want to give a little bit of a history of this process. One of the things that I found fascinating as a scholar that studies the confirmation process is the way that this has changed over time. And more specifically, the increasing politicization that has occurred over time and the escalation of the politics of the Supreme Court over time. To give you an idea of this, we have never spent, prior to the last 30 years, as much time asking justices questions as we do now. The last 30 years is the only time in American history where we require nominees to answer as many hours of questions than they do. To give you an idea of this, in 1925, Justice Stone, he was asked for 5 hours worth of questioning. 1938 and 1955, Frankfurter and Harlan weren't asked any hours. 1957, Brennan was asked 3 hours of questions. 1967, Marshall was asked 7 hours of questions. 1971, Rehnquist was also asked 7 hours of questions. 1975, Stevens was asked 6 hours of questions. And in 1981, O'Connor was asked 12 hours of questions. O'Connor's questions were nearly double all of her predecessors. Okay? Even if we include her within that particular history, the total hours in the confirmation hearing process from 1925 to 1981 was 38 hours. Okay? And then came a historical moment in the Senate confirmation hearings. There was a nominee, Judge Bork, and he was nominated to the Supreme Court. And there was mass opposition to Bork by the Democratic Party. The Democratic Party subjected Bork to 30 hours of questions. 30 hours, okay? This upset a lot of conservative supporters of Bork, made them start resenting this kind of treatment of Bork, because never before in the history of Supreme Court nominations had anybody had to undergo this particular treatment. The President of the United States nominated, the Senate did their job of doing it, and they were basically entrusted, whether it be a Democratic appointee or a Republican appointee, to be able to make that determination. And for better or worse, there were a lot of resentments that were built into that particular process. After that particular hearing, and after Justice Kennedy was eventually confirmed to fill the original nomination that Bork had been nominated, we then had Souter that was questioned for 20 hours. Again, almost twice the amount that O'Connor was, and almost totaled the whole number of hours prior to her, right? So we had Souter at 20 hours, Justice Thomas at 25 hours, Ginsburg at 20 hours, Breyer at 20, Roberts at 20, Gorsuch at 20. You get the idea. So in the last 30 years so far, not counting Judge Kavanaugh, they've asked a total of 166 hours of questions to Senate confirmations. Now, should they or should they not? I'm not here to reserve a judgment on that particular question. I will note, however, that the result of that is, over time, an increased politicization of the process, increased resentments from both sides of the aisle, increased resentments when a Republican appointee or nominee comes forth and is confirmed, or a Democratic nominee is put forth and is confirmed. The resentments heighten, right? And so we've got this, so that's kind of the context under which we have the recent controversy. Furthermore, that proliferation of back and forth continued with the nomination of Judge Garland. Anybody familiar with the nomination of Merrick Garland? Anybody? No, not really? Kind of? A little bit? A few of you? Yeah? So President Obama nominated Judge Garland to replace Justice Scalia after Justice Scalia had died, right? After that nomination, even though the Senate had over a year before they would be actually confirmed, the Senate refused to give Garland a hearing. They said that a presidential election was happening later that year. I think it was 9 months or so, from January to November or so. It might have been February. It was around that time, if my memory serves me correctly. So we had about 9-10 months or so in between. And they said that because there was an election year happening that time, the people would be able to have a memorandum on who they would want to be nominated for the Supreme Court, because that would be the outcome of the presidential election, right? So they refused to give Merrick Garland a trial. So now the further resentment is fueled because Democrats believe that they were wronged, that nowhere in the history of the United States have we waited that long for a confirmation hearing to take place. And so now we've got Judge Kavanaugh nominated, and we've got this political firestorm over the whole thing, right? So that's kind of where we currently are sitting. Let me talk a little bit about how the justices seek to share their interpretation without the politics of the situation. The question that has been asked by some scholars, for example, is, if we presume that judges are true to their word and they interpret it based on these definitional questions, how would a judge ever make that kind of case in the current political context? What would that even look like? How would a judge stand up and say, I take things on a case-by-case basis? Yes, my rulings may be more conservative in nature, or they might be more liberal in nature, but conservatism and party loyalty and all of those things are not relevant to the way that I interpret the Constitution. Some scholars have said that's impossible in our current political context, right? Even Justice Ginsburg has come and said that she doesn't believe that Judge Kavanaugh has been given a good shake in this particular process. Some note the delineation between judge and justice, right? So some scholars argue that in this current confirmation process, if you're qualified to be a federal judge, then what makes it different to be qualified to be a Supreme Court justice? If the things that are so bad, if the Republican questioning of a Democratic appointee or a Democratic questioning of a Republican appointee is so legitimate that it makes them unqualified to be a Supreme Court justice, then why wouldn't that also be grounds to make them unqualified to be a federal judge? And if they are unqualified to be a federal judge, then shouldn't we be taking that information and making it grounds for removal, impeachment, etc., right? So some scholars have questioned this process on those particular grounds. Some have noted that as long as they're framed politically, they will always be perceived to be acting political, right? That there's no way of escaping that. Even if a judge is trying to make a case that they may or may not be conservative or liberal, but rather interpreters of history and text. I'll get to questions in just a second, for sure. So I'd like to just offer a general conclusion, and then we'll open it up for some questions and conversation. But when we think about the future of the court, I think that there's a few things that we can look at. The first of which is to look to see how the next appointment affects the dynamics of the court. Occasionally, members join the court and they can influence their peers. They have an impact on their peers. It might change the way that they think on particular issues and on particular cases. We might also look to some of the legacy question that Chief Justice Roberts has alluded to on a number of fronts. Chief Justice Roberts has made it fairly vocal that he's not in favor of the public perceiving it as an ideological court. He's not happy with this particular perception because he doesn't view the court as working in its business that way. Advocates of this particular point of view would argue that if you look at the most common decision of the court, what do you think the most common decision of the Supreme Court is? What's their No, the most common opinion. Is it 5-4? Is it 6-3? Is it, what's the most common? 5-4. That is not true. All right? The most commonly occurring decision of the Supreme Court is a unanimous decision. Really? Yes. The most common reached decision of the Supreme Court is a unanimous decision. Now, we hear about the contentious 5-4 cases because of the politics, right? However, even the 5-4 cases don't all occur along party lines, right? Tell me some of the most controversial cases that have been decided in a 5-4 way.
Abortion. Roe v. Wade.
Okay, Roe v. Wade. Were there Republicans in the majority?
No.
Republican appointees? None.
No.
Not one. What other case? I believe that is untrue in terms of at least upholding the Roe v. Wade as precedent. I know that at least Sandra Day O'Connor has been in the majority of certain abortion cases, right? So if it was party lines, they might be opposed to that interpretation up front, right? What other cases can you think of that are 5-4? It's a big ones.
The Colorado cake shop.
That wasn't a 5-4, right? I believe that was a 7-2 decision, right? How about Bush v. Gore? You got presidential candidates, right? Bush v. Gore, fighting it out in court to decide a presidential election, right? And in the 4 are 2 Republican appointees. And not only that, one of those appointees was Justice Souter. Who was Justice Souter appointed by?
A Democratic presidential.
Nope, Justice Souter was appointed by George H.W. Bush. So Justice Souter, appointed by George H.W. Bush, ruled against Bush in Bush v. Gore, right? Justice Stevens was a Ford appointee, right? A President Ford appointee, a Republican appointee, dissented in Citizens United, right? We've got justices that change their minds. Another 5-4 case, the individual mandate of the Affordable Care Act. Chief Justice Roberts was in the 5 in the 5-4 decision, upholding the Affordable Care Act, right? How do you explain that? Well, the modalities might get at it, right? Because there's a pragmatic interpretation to this, okay? And I can get into that maybe a little bit later. But the point of the matter that I'm trying to make is that a rhetorically minded person that interprets the Constitution in a very complex, dynamic, multiple interpretation kind of way reads judicial opinions in a variety of ways and pays close attention to the arguments that people are advancing. So, for example, if we take a look at even Judge Kavanaugh's ruling, right? As a conservatively oriented judge, no doubt framed in that particular way, has a lot of decisions that have those kinds of outcomes, and yet at the same time has ruled in favor of employees in discrimination cases, right? or at least in one case in particular, right? He's ruled, there were 2 constitutional challenges to the Affordable Care Act that the Democrats had advocated. And he wrote against those constitutional challenges to uphold the Affordable Care Act. It's more nuanced. Is it ideological at times? Probably, and no doubt. But the major decision in the Supreme Court is not a 5-4 decision. Those 5-4 decisions are impactful. It's not meant to minimize the importance of it. In fact, it might be the defining element when you are voting for a president of the United States, especially when it comes to executive powers, when it comes to the way that Congress is able to enact laws, the overreach of different branch powers and so forth. All those questions are at issue in a presidential election. And it may decide the future of the court. It's done so on numerous occasions in American history, most notably when FDR not only nominated 1, but got 3 appointments to expand the court from 7 justices to 9. There's nothing that says that we can't expand it even today from 9 to 11. If President Trump wanted to make the argument and they conceded to allow him 2 more appointees to the Supreme Court, to make it an 11-member court, right? Or if the next president of the United States wants to appoint 3 justices, right? There's any number of possibilities that have broad implications for the way that we interpret the Constitution. And so now I'd like to open up to address maybe some of the questions you have about this process. Yeah.
Yeah, the 5-4 decision for Gore Bush. I thought the Supreme Court is not allowed to dabble in politics, and that's a pretty politicized, something that's quite political. What's going on?
Right. So the distinction that you draw out, I think, is really telling. Something that becomes politicized doesn't necessarily mean that to the justices it is politicized inherently, right? For them, one of the reasons why they view their own tenure, if you will, is not to be concerned with the politicization of that. For them, they want to try to read the Constitution the way that they think it should be read, right? They do so they have their different matrices. So that's my purpose in kind of sharing those matrices, right? Some might be like sitting there, I imagine in a rocking chair or something, right? And like, what is the ethical principle in this? What does this mean for the larger shape of democratic life, right? So justices who have been around for a long time, right? Maybe 30, 40 years. Maybe they were around to live through Brown v. Board of Education, right? Well, in a sense, they do because they build on precedent.
But did that decision set a precedent?
Bush v. Gore?
Yeah.
Yeah, I mean, every decision that the Supreme Court makes sets a precedent. That certainly they can be involved in stopping a recount, for example, right? They could turn to Bush v. Gore. Now, some 5-4 opinions get reversed because they find over time that the arguments of the 4 might be more telling in a given case. That's the other difference between the Supreme Court and other bodies. The Supreme Court can't just legislate out of thin air. They have to have a test case come to them. They're a reactive body. They respond to particular crises. So they can't just sit there on the court and say, you know what, I want to make abortion illegal and unconstitutional now, right? They have to have a case under which they could do that. And the case is not necessarily easy to come by, right? You're talking about a lot of resources, the creation of dramatic exigencies. You're talking about the moving through the court system. They can't just take a court from the lower without going through the process, right? It's got to be filed in a particular way and in that due process, right? And so, yeah, it sets precedent. You know, everything the Supreme Court does and says and rules in sets a precedent. Sets a precedent because other lawyers that are arguing in front of the Supreme Court will draw on those arguments to be able to make their briefs and file those in front of the Supreme Court. Any other questions? Yeah.
You said that certain justices have been asked up to 12 hours of questions for a hearing.
25, 30, and in the case of Bork, 30. In the case of Sandra Day O'Connor, 12. Yeah.
What would be some of the typical questions they would ask that would make it go on for that long?
Probably anything that you can imagine. They are asking questions about their interpretation, right? So they might say, okay, so in this decision that you made in the lower court, for example, when I read your opinion, explain to me how that fits within your reasoning process that you go about interpreting the Constitution, right? Could range from that to, in Justice Kagan's case, where are you on Christmas, right? And she's like, well, that's a difficult question, Christmas, blah, 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 right? And the senator says, no, I'm actually asking, where are you on Christmas? And she answers, well, like any Jew, I'm at a Chinese restaurant, right? And it gained a bunch of laughter in the Senate and so forth. And so it ranges in the types of questions they could ask. They could ask a question that they're probably not going to get an answer to because the justices are about the cases in front of them, but they might ask, so do you think that Roe v. Wade is standing precedent, right? To which they'll say, well, yeah, it's been decided by the court. Let the decision stand. No justice has said that it's not precedent when they're in front of the Senate, right? Good questions. Any other questions? What else? Yeah.
What's the fifth modality?
What is the fifth modality? Well, okay, so I just want to be clear, they don't go in order. It's not like, but the fifth one that I covered was the structural modality.
What was the first one you covered?
The first one that I covered was the historical modality.
Are there ever any situations where they say that a decision that they made early on in their career is something that they would not decide to say now?
That's a good question. I can't anticipate, I can't think of a moment where they've said that they would have changed their mind given the way that they were deciding at the time. They'd be more likely to say that it was appropriate at the time, and the Supreme Court has ruled these particular ways since and overruled that my lower court decision. So the current decision that they are ruling on obviously would stand and take precedent, right? So I'm not familiar with them ever saying my reasoning would have been different.
I believe you said something about one of the justices and how the public views the Supreme Court, and you said, I forgot how you described it. I just want you to go over that again.
So the question is about how the public views the court.
Yeah, you said
So even in my own language, admittedly, and I'm a scholar of this, I sometimes fall trap into describing it as a liberal and conservative court. You know, I probably said it a few times today in the lecture, right? And so we fall trapped to thinking about it as a liberal and conservative court because that's how it's framed to us in popular discourse, in public discourse. What I think is more accurate when you're actually reading the texts is that it doesn't always fall along those lines. If it did, there wouldn't be cases like Brown versus Entertainment Merchants Association, where two originalists like Justice Thomas and Justice Scalia decide in opposite ways. There wouldn't be cases where Chief Justice Roberts sides with President Obama's Affordable Care Act as a George W. Bush appointee. There wouldn't be cases where Justice Gorsuch writes a dissent against 8 members of the court, or Justice Alito writes a dissent, more accurately, against 8 members of the court in a couple of the cases that he's decided in his tenure, right? If it was truly an ideological court, you would be able to see conservative and liberal consistently throughout, and the most common decision that we know of is a unanimous one, and we know that there's a lot of nuances that exist within where the conservative liberal breaks down. It's not always a 5-4 split. Can it be a 5-4 split on ideological lines? Of course. That's happened. We've seen cases that are like that come down where Democrats would think this and liberals and Republicans would think this, and the Republicans win their side 5-4, right? But there's a lot of dynamics of the Supreme Court that don't always play out that way. And more importantly, justices can change their mind, especially with the recent studies that indicate that people may trend toward more liberal opinions as they get older in age, right? So they may trend back, right? So the research is like people who are liberal might go to be more conservative as they get older, and then just in general, right? And so as they get a little bit older, then they might trend a little bit more conservative, and then they reach a point to where they go back a little bit more liberal, right? And they may start off conservative, and get more conservative as they get to a certain point, and then they hedge back and they become a little bit more liberal, right? And so there's opinions that there's some evidence out there that indicates that within our psychological journals, for example. And so maybe there might be an effect of that, and that's why Justice Kennedy may have grown into being a more moderate justice, deciding a lot of 5-4 cases in his time, right? Yeah.
Would Supreme Court justices self-identify as prescribing to certain modalities, or typically are these modalities prescribed onto them based on the way that they rule?
It's a little bit of both. I think that if you're interested in that question, you can see a lot of the dialogues that have happened in public forums between Justice Breyer and Justice Scalia, for example, right? So they disagreed on the question of reinterpreting the Constitution to meet demands, right? So they've had these conversations. Some ascribe to themselves a whole lot more to history, for example. Some disavow themselves from history a little bit more and say, hey, it's a little bit more complicated, right? Justice Sotomayor's wise Latina remark in her Senate confirmation hearing, for example. And so you get a lot of different interpretations where they might not be using the vocabulary of Bobbitt's modalities. They may not be, I am a historical, a textual, and a prudential justice. I don't know that you'll ever see them or hear them say that. But they'll certainly allude to that as their guiding philosophy in interpreting it. And they'll do it to varying degrees. No justice is ever going to necessarily, well, maybe there are some, but I, off the top of my head, would be inclined to say that some of the justices, like Justice Scalia, might not ascribe to the ethical modality and might say, I'm not ethical, but many of the justices would not be entirely separated from other modalities. So for example, someone that might be more likely to interpret it based on an ethical modality like Justice Ginsburg would never say that history isn't part of her decisioning or reasoning process. She doesn't necessarily think that we're just making decisions out of thin air, right? It comes from someplace from the past. Stare decisis, the history of the text. So is history important? Yes, to her, but that's not how she's going to predominantly work through her hermeneutic, her grid, her way of interpreting the acts and cases that come before her. Okay. I'll hang around for a little bit more afterwards, but I just wanted to thank the members of the public for coming via camera, and I applaud you to celebrate Constitution Day in a number of ways, not the least of which is to read about the Supreme Court justices, learn about the 8 current Supreme Court justices, and I teach a course in this stuff. If you're willing to learn more about that, you can do that, or you can take several other courses here at Long Beach State that take up that kind of subject matter. So thank you for having me today.